Dr. Chia.
Mr. Speaker, sir, I rise in support of this bill, which will further strengthen the current legislation to provide protection against harassment. I think one of the key amendments of this bill is the establishment of the Specialist Court, the Protection from Harassment Courts, or the PHC, which will provide a one-stop center for all matters relating to protection from harassment. This arrangement will certainly facilitate the provision of holistic and effective interventions for victims. I think two of the main concerns of harassment victims are the time required and also the difficulties faced in getting protection orders or POs. I am heartened to note that the PHC will adopt simplified procedures and expedite the hearings of certain applications, for example, within 48 to 72 hours for expedited protection orders or EPOs, and where there is risk of violence or violence has already occurred within 24 hours. The decision to permit the PHC not to be bounded by the rules of evidence in the conduct of civil proceedings will also be very helpful for victims. I would like, however, to seek some clarifications on the enforcement of protection orders once issued. The bill indicates that the remedies and recourse for breaches of POs and EPOs will be strengthened. The measures include the issuance of community orders, and in the cases of causing hurt or continued harassment, making such breaches arrestable offences. Now, my concern is that these are implemented after the breaches, by which time the victims would have suffered another round of psychological or physical trauma. In cases where the accused may be unable to think rationally, nor behave with restraint, there seems little to prevent them from causing more trouble. I've encountered some of these cases in my dealings as a Member of Parliament. For example, we had a daughter and her mother who felt they were threatened by one of their sons. And although I do not have the full information about the case, but it was clear that they felt that this son was not behaving rationally, and they were in constant fear of being attacked or harassed by this son, despite the existence of protection orders. And there was very little in terms of immediate recourse that they could turn to. So is it possible to introduce stronger deterring measures to enforce the POs, and can more be done to prevent subsequent harassment or attacks? Will the Ministry also share recent data on the effectiveness of POs, including the number of cases of repeated breaches or subsequent injuries or perhaps even deaths? Next, like many members before me, I do welcome the amendments to counter the unfortunate new social trend of doxing, where people's personal information such as names, photographs, contact details, home and work addresses are shared online in order to facilitate harassment, issue threats or cause physical harm. I think many examples have been shared in this House over the past hour. I myself have also encountered some examples, maybe of not such an egregious nature. For example, several months ago, I came across a cleaner in one of the hawker centres who had a little bit of disagreement with one of his customers. And it so transpired that the details about the cleaner were then posted on social media, which led to a lot of consternation to this cleaner. Of course, notwithstanding the merits or lack thereof of the case, I think these are very unfortunate developments in the social media arena. So some of these acts of online vigilantism, such as exposed a couple who harassed an old man in a hawker centre, inconsiderate and dangerous drivers, voyeurs and peeping toms, may seem warranted, but in fact undermines the very foundation of our justice system. Administering justice is not an activity which can be done part-time, remotely, nor casually. Thorough investigations of the facts of the events are necessary in fairness to all the parties involved. In fact, there have been many cases where false or misleading information had been shared, causing hurt and damage to innocent parties. I urge the Ministry to step up awareness of what constitutes the legal act of doxing through public education programs, as well as appropriate measures the man in the street can take to address bad social behaviours. A number of netizens do resort to doxing because they lack confidence in government institutions to rectify certain situations and social behaviours, leading them to take matters into their own hands. It is important that public institutions concerned show their awareness of these incidents and prove that the government takes a serious view of this feedback through comprehensive measures and consistent enforcement. Public education to increase their awareness of the appropriate forums to share such information is essential. For example, they should be encouraged to post and share videos of, for example, dangerous driving with the traffic police, forward information on disputes to the relevant authorities, and share information with emergency services. In order to reduce the incidence of doxing, public institutions must be prepared to step up to address public concerns expeditiously and provide updates on actions taken. As it has often been said, not only should justice be done, it must also be seen to be done. Thank you, and I support the bill.